We have dissolution of marriage, which is your basic divorce. We have establishment of paternity. There is child support, child custody, dependency cases, adoptions, and domestic violence.
Welcome back to another episode of Law Unpacked. I'm your host, Attorney Sean, and today we're diving into the foundational steps of starting a family law case here in Florida. Whether you're considering divorce, filing for custody, or seeking support, the initial stages can feel overwhelming. My guest today is Joshua Tyson, our family law attorney here at the DeVries Law Firm. He is going to guide us through the ins and outs of filing a case in Florida, covering everything from paperwork to court proceedings to even the rules of family law court. By the end of this episode, you'll have a clear understanding of how to start your case with confidence. Let's go ahead and get started. Josh, welcome to the show.
Thank you, Sean. Nice to be here.
Let's go ahead and start with the basics. Family law covers a wide range of cases, and understanding your situation is a first step. What type of family law cases can be filed in Florida?
So for Florida, we have dissolution of marriage, which is your basic divorce. We have establishment of paternity. There is child support, child custody, dependency cases, adoptions, and domestic violence.
Well, that seems to be, a whole lot of them. So let's start with the basics. And I think when most people think family law, they're thinking divorce and separation. So really, what's the difference between divorce, separation, and annulment here in Florida?
So a divorce is your dissolution of marriage. That's where the court's going to separate all of your assets and debts. If there are any children, they'll determine how the children will spend time with each parent. In Florida, we don't have legal separation. That is something other states do have, but it's not something required in Florida. An annulment is when the court determines that the marriage never actually occurred. And those can be either voided or voidable by the parties, depending on the situation.
So how does Florida law define jurisdiction for family law cases? And let's take that one step further and to our clients and and our listeners and potential clients, what exactly is jurisdiction?
So there are two types of jurisdiction. The first is subject matter jurisdiction, which is not a huge issue for family law cases. The court will have jurisdiction over the dissolution. The main one you'll be worried about for family law cases is your personal jurisdiction. The court's going to require that one of the parties has lived in the state of Florida for at least 6 months prior to filing.
So at what point should someone consult an attorney about a family law matter?
What I always tell people is as soon as possible. There are a lot of rights that you could be missing out on. If the other side has already filed, there are deadlines to get your responsive pleadings in. And if once you file, the other side is locked into certain things. One of the examples I always give potential clients when I'm discussing it with them is when the other side potentially wants to move to another state or at times another country. Once you've filed, they cannot move out of state with the child without the approval of the court. And if you haven't filed, they're certainly free to do so.
Now, are there any time limits for filing a family law case?
Not any hard time limits for filing. There are for filing responses, and that's why you'll want to make sure to get with an attorney as soon as possible so you know those deadlines, such as your initial responsive pleading you have 20 days for. To turn in your mandatory disclosures for discovery, you have 45 days from the time you're served.
And I think we're going to get into what pleadings and what discovery is later in this episode, but what are some of the common misconceptions you hear from potential clients or clients regarding family law cases?
So most of them revolve around the children, like the mother being favored in the state of Florida. Again, that's a common misconception. The court has a presumption that 50-50 time sharing is in the child's best interest. And then you have that the parties can waive child support, which is untrue. That is a right of the child, so neither party can waive it. Or if you have 50-50 time sharing, that there would be no child support. Also untrue. If one party is making significantly more, even in a 50-50 time sharing, you could have an award of child support.
And going back, a follow-up question. So what I think I'm hearing you saying is even if it's not a 50-50, there's a presumption of a 50-50, but Let's say they give dad 75 and mom 25, but if dad makes significantly more, in theory, they could still award mom some child support.
That's correct. We've had some rare cases where that occurs, where one party's making a significant amount and is the majority parent, and they still owe child support to the non-majority parent.
So now that we've covered the basics, let's go ahead and move on to what you need to prepare before filing a case. Preparation is key to success in any legal process. What documents are typically required to initiate a case here in Florida?
So to initiate a case, you're going to need a petition. You'll also need a summons that allows the process server to give the documents to the other party and lets them know that they have 20 days to file a response. You'll want to file a notice of related cases to let the court know whether or not there are any other cases involved, such as if there's child support and you're filing a custody case, or if you're filing a divorce and there's an associated domestic violence case. The court will want to know those things, and you would put that in your initial filing. Also, if there are children involved, you'll want to do what's called a UCCJEA, Uniform Child Custody Jurisdiction Enforcement Act.
But what do clients need to be able to prepare for these pleadings, like a marriage certificate or birth certificate? What exactly should a client be doing to gather those documents to be able to take into their attorney?
So, no documents that we particularly need off the start for filing. We'll ask for a driver's license. That's just to show the court that you are a resident of the state of Florida. If you don't have one of those, we can prepare an affidavit of a cooperating witness. But we do ask that when initially coming in, you can bring us any financial documents, which you'll need to turn over to the court anyways later, or evidence that you might have so that we can assess the strength of your case to give you realistic expectations before we begin.
Well, you bring up evidence, and obviously, somebody just doesn't say, today I'm filing for divorce or today I want to file for custody. What type of evidence are you speaking of that a client should gather in order to be able to present their case in the best light possible?
You'll be looking for text messages, emails, communications between the parties is the main thing. Like I said, also the financial documents. That is the main crux of the discovery that we do with our clients.
And what about any, let's say if there's a domestic violence issue, is there any other documentation that they should bring to be able to be reviewed?
Certainly, if there's domestic violence, you'll want to bring any court records of that, any police reports, statements from any witnesses.
So, what information should someone provide during their initial consultation?
So during the initial consultation, I usually ask for as broad a narrative as possible, just because there may be relevant information that a potential client doesn't even know is important to their case, that can either help or hinder. And we would want to know that right off the start so that we would know what direction we want to take their case and what their goals should be, and if we can meet the goals that they have for themselves.
Now, still sticking on the subject of presenting their case in the best light possible, how important is financial documentation during family law cases?
It's critical. Like I said, it's mandatory for financial disclosures to be made within 45 days. Not doing so greatly angers the court generally. Also, the court's going to want to see that you're being candid with them, so not providing those documents can definitely hurt your case.
Would you state that, or would you agree that during family law cases, really being organized in your financials is probably one of the ways that you can minimize legal costs in a family law case?
Absolutely. Having your attorney have to continuously reach out for your financial discovery, having it not organized when you turn it over, that's a lot of extra work that has to be done by a firm. And if you're not turning it over, you'll also be subject to additional hearings, which are additional filings that would need to be done by your attorney. So yes, that is one of the greatest costs of a family law case is the financial discovery portion, and not having it organized can certainly increase those costs more than most other instances in your case.
So there's a lot of talk and a lot of noise, and people are wondering, how does mediation fit into the process of a family law case here in Florida? Is it something that you do ahead of time? Is it something that you do during the case? What is mediation, and when is that part of the case?
So, mediation is a time for both parties to come together and try to work out a resolution without a judge making that determination. It is required in family law cases here in Florida, and will very rarely be waived. In a divorce, you'll try to work out how the two of you want to split things up. You have a lot of freedom, so it's a great time to really push for what you want, and get this done and save yourself a lot of time going through a trial with the court.
Well, what happens if one party refuses to cooperate in mediation?
The court orders you to mediation, so they order both parties to go in good faith. If they don't, you could request the court to have them attend again, and for the party that refused to cooperate to bear the entire cost of the mediation.
So, going back to domestic violence, we touched on it just a few minutes ago. How does domestic violence impact the initial stages of a case?
So, when you have a domestic violence case already in place, there's generally already going to be exclusive use and possession of the home. There's likely going to be a time sharing plan put in place temporarily, possibly alimony and child support already factored in. So you'll be starting a family law case with a lot of the temporary issues already resolved. From there, the domestic violence court will generally pass that case to the family court to make any further determinations and modify that as the family law case sees fit.
Well, what if they're just starting out? Let's say domestic violence just occurred and
Okay.
there was just an arrest. Now, where does the family law case come in there?
So with there, you'll likely be filing both of those together, a dissolution and a domestic violence injunction together. The court will likely want to hear all of that together, and make a determination under the family law court about whether or not an injunction will be in place. And like I said, that gets a lot of the temporary issues of the case heard very quickly.
So I just read, and it's very hot news that Florida is one of the fastest growing states in the country. Going back real quick, what happens if one party lives here in Florida and another party lives in another state?
So, as long as you've lived in Florida for 6 months, the court would have personal jurisdiction over you. You're free to file here. The other party would need to be served in the state that they are in, and your case can presume here, assuming they don't challenge the venue and ask for it to be moved to the state that they're in.
And so, just for clarity, and for those that don't know, when you speak venue, what is venue?
Venue is where the case will be held. So we're in Duval County. Duval County would be the venue. You'll generally want that to be, if there are children, where the children are, or where you're currently living.
And you talk about serving somebody. Exactly what is serving somebody, and why is that important?
A process server is sent out, and it lets the court know that this person has received these documents. They've been placed in their hands. There's no ability for the other party to say, I never received these documents. Now, we hire a process server. They are licensed by the state. They go out and they fulfill the service. And they sign an affidavit and present it to the court that they delivered those documents to the other party.
So we've already really jumped into filing, but I want to really get into some of the nitty gritty of that initial pleadings. So once you've gathered your documents information and it's time to file and officially begin the legal process, what happens next?
So once you file those initial documents, the other party is served. They have 20 days to file their response, and I believe we discussed it earlier than 45 days to file their financial disclosures, as do you. From there, we'll be trying to work out a resolution on your case. If not, the court will order the parties to mediation once that discovery is completed.
So filing a case is where things officially start, right? And it's important to understand that the paperwork and the fees and how to notify the other party. What is the process for filing a family law case in Florida, and what are the fees involved?
Sure. So the process for filing, if you have an attorney, the attorney will file on your behalf. We have an online portal that we use for filing once the documents are completed. If you'd like to file online as a pro se litigant where you're not represented by an attorney, you can sign up online and do so through that same portal. Otherwise, you would have to go down to the courthouse and file with the clerk's office. Now, there are fees associated with filing. It's $401 to file a divorce, it's $301 to file a child custody case.
Is there any situation where those fees might be waived?
Certainly. We have what's called an affidavit of indigency waiver, where you request that the court waive the fees for you. Now, I can say that if you do have an attorney, it's unlikely those fees will be waived. The courts generally won't do so if you're hiring private counsel. However, one thing that we often do with people is they will hire us to do their initial paperwork and then request to file on their own and file that waiver, file for the waiver, and then hire us afterwards if the waiver is granted.
So you do that first filing, and we talked a little bit about serving, using servers or exactly serving people. How does service work here in Florida?
So the documents are sent to the courthouse. From there, we pay a fee, and they have the sheriff's office go out and serve the documents. You'll put the address that you want the officer to go to in the summons, which is in your initial filing.
And then what happens if the other party avoids service, or if they can't serve the other party?
Yeah, if they can't serve the other party, we can do what's called constructive service. It's not something the courts particularly like to do, but they understand that it's necessary at times. So the process server would file an affidavit of non-service that they were unable to locate the other party or that they were avoiding service. At that time, the clerk's office will give you a notice, which allows you to post that their pleadings have been filed against the specific person in your local newspaper. It would need to run for 4 consecutive weeks in the local newspaper, and then the courts will proceed as if that person has been served.
So let's talk about assuming somebody decides they want to file divorce on their own without the benefit of an attorney. What are the consequences of filing incomplete paperwork?
So, consequences for incomplete paperwork. The clerk's office, if it's incomplete, will generally deny your filing. You could waste a lot of time and money and lose some legal positioning, especially if the other party finds out that you are looking to file. They could start positioning themselves to prepare for that.
Can legal aid or pro bono services help with filing?
Certainly, we've got some pro bono and legal aid here locally. I know we have Jacksonville area legal aid that assists with pro bono or what we call low bono, low cost assistance with filing.
So now that the case has been filed, the other party's been served, assuming maybe the other party's been served, at what point, what are temporary orders and how do they work?
So a temporary order is put in place. It's for the generally for the pendency of the case, and it's so that parties can't intentionally drag their feet and prolong things to stop generally time sharing with the other parent. You would need to file a motion for temporary needs, have it set with the court, and from there they can put those orders in place. And it's only going to last up until the end of your case, or the court may give a specific date when that temporary order will end.
So those are temporary orders, but what's the role? Let's talk about emergency orders. What are emergency orders and what are they needed?
So, emergency orders are only allowed by the court when one of the parties or the children are in imminent danger of physical harm. Um, it's something the courts don't like to put in place, something we generally recommend against filing just because they are very difficult to get. But emergency orders are when generally we need a pickup order. We're going to need JSO to go assist in getting the children or protecting one of the parties from the other.
So after filing, navigating the court system really becomes the focus. Let's talk about what to expect once your case is in motion. Family court can feel overwhelming, but understanding the process can make it much more manageable. So tell us, what should clients expect during first court appearance?
So during the first court appearance, it'll depend on what you are there for. Some counties have a case management conference to let you know what to expect moving forward. With that, they'll go through things like your deadlines for discovery and for filing pleadings. Otherwise, you'll likely be in a temporary hearing on your first appearance. You'll be giving your testimony, being cross examined by the other side. presenting your witnesses and presenting any evidence that you might have for the court.
How does Florida's family courts differ from maybe other states?
So, Florida is a no fault state. So, the courts aren't going to be looking for the reasons for the dissolution. They're just going to be looking at what are the assets, what are the debts that need to be divided, putting your child custody time sharing in place, and that's it. They don't want to hear about your drinking problem or if there was adultery or abuse. Now they may want to hear about those when it gets into the children and other issues, but solely for the divorce and the division of the property, they don't take that into consideration.
So we talked about first filing the initial paperwork. Then we talked about having them served. What happens if a party doesn't respond to the case?
So the court will enter a default. If they don't respond, they will go ahead and give you your divorce. You'll be able to divide the assets. They will put a time sharing plan in place. Now, the time sharing plan can always be modified moving forward, and the party can request to set aside that default later, but they'll need to show the court good cause as to why they didn't respond in a timely manner.
So I know, some cases can be very quick where parties agree and can settle it themselves, and other cases can drag on for years because there's so much disagreement and um, animosity between the parties and kids and lots of assets and companies. But how long does it typically take the average case to proceed?
So, for a divorce, on average, I would say about a year, and that's if we're going to trial. Because we do our initial filings, we have the other party served. Like I said, from there, it's 20 days for the responsive pleading, 45 days for the discovery. Once the discovery is done, we get set for mediation. Now, it varies depending on what mediator you're using. The one that I use personally is booking about 4 months out. And if you don't have an agreement at the mediation, your judge may be booking anywhere right now from 2 to 6 months out.
So are there specific judges assigned to family law cases, or are they heard by any judge that's available?
So yes, once you file, it's going to be assigned to a specific judge. Every county has different divisions, and each division will get its own cases, and that judge hears those cases. Here in Duval County, we have divisions A through G. All of them have their own judge that is assigned, and if your case goes to that division, that's the family law judge that'll be hearing your case.
How does the judge decide whether a case needs a hearing or a trial?
So generally, before a trial, you would do what's called a motion to set, and the judge would go over some of the items that you'll be discussing. You'll let the judge know what is at issue, whether that be just time with the child or assets and debts. Make sure everyone has all of the evidence that they need from the other side and that everyone's ready to proceed. If you're not, he may order you to mediation. He can order you to mediation multiple times if he feels it's not ready. He can also order a variety of different things, such as social investigations, parenting coordinators, things of that nature.
Can someone represent themselves in court during these hearings and trial?
They certainly can. It's not something that we recommend, but it is something that people do and quite regularly. There's nothing stopping the court from doing so, but they will be treated as if they are the attorney, and there's no leniency for you if you are acting on your own behalf.
What are some of the other disadvantages that would be on filing yourself or representing yourself in a family law case?
Some of the disadvantages to representing yourself is not knowing rules of evidence, what is allowed and what's not. The other side may be trying to present something that they can get in, but if you were to object to it, the courts would refuse to look at. So you could definitely be letting a lot of um, evidence that should not be seen by the court in by representing yourself.
Well, Josh, thank you for your time today. This wraps up our discussion on starting a family law case. I hope this episode gives you the clarity you need to take the first steps in your legal journey. Remember, preparation and understanding your rights are key to navigating this process successfully. If you found this episode helpful, be sure to subscribe and share it with someone who might benefit. Next time, we'll dive into the intricate world of divorce and what you need to know to protect yourself legally and financially. Thanks for listening to Law Unpacked or watching. Don't forget to follow. I'm Attorney Sean. See you next time.